Judge Parker sure stirred up a bee's nest when he gave the jury instructions. Not only did he not mention the conspiracy before the fact concerning the assassination of Town Marshall James Cockrill, but he also turned the law on its head when he gave the instructions about whether or not James Hargis should be found guilty on any charges at all. The people of Breathitt County were not happy, and neither was the prosecution. Come along with us as we walk through the jury instructions and the verdict the jury would render because of them. All aboard the Kentucky-Tennessee Living Time Machine. Please fasten your seatbelts and keep your arms and legs inside of the vehicle at all times. But to get going, we need your help. We still need to fire up that time machine to transport us. Please help us by clicking on the like, subscribe, and bell notification buttons down below. Not only does this fire up the time machine for our flight back in time, but it convinces the YouTube algorithm that we need a bigger vehicle to reach more people who love history as much as you do. Now, back to our story. Closing arguments. While we do not know what was said during the closing arguments of the case, we do have who stood up to speak on behalf of the two sides of the case. The May 5th, 1905 Breathitt County News reported the following. Quote, both sides closed Wednesday at noon, and the afternoon was taken up in arguing on the instructions. The arguments on the case were begun Thursday morning. George Hunt made the first speech for the defense, and was followed by B.F. Byrd for the Commonwealth, followed by E.P. Farrell for the defense, C.J. Bronson for the plaintiff. J.R. Lee will make the closing argument for the defense, and Colonel John R. Allen, blank, prosecution. The next sentence is unreadable, unquote. So the order went defense, prosecution, and so on until the prosecution had the last argument to give. Because there were holes in the newspaper because of time, we are still able to read just enough to find out who were the attorneys for each side of the case. We will now move forward to the jury instructions. Jury instructions. It would seem that the judge's jury instructions were not up to par. This would cause a lot of upheaval in Breathitt County. The Commonwealth's attorneys would take their displeasure of the court's instructions to the appellate court. But for now, let us see exactly what the upheaval was about. According to the May 12, 1905 Breathitt County News, quote, the Hargis case. Judge Parker surprised the whole country on last Thursday when he refused to instruct the jury to find against James Hargis for being an accessory before the fact in the assassination of James Cockrill. Nobody has ever claimed that he fired the fatal shot, but it was the contention of the prosecution that he counseled, advised, and encouraged those who did. And it seems that they proved beyond a reasonable doubt the truth of their allegations. But when the evidence was all in, they were dumbfounded when they found that the judge practically instructed them out of the court, unquote. This was shocking. In one fell swoop, Judge Parker had turned a conspiracy case into a murder case. There would be no evidence that Judge Hargis shot anyone. However, there seems to be an extreme amount of evidence that he masterminded the plot and participated in a cover-up after the fact when Town Marshall James Cockrill was killed. In the May 6, 1905 Daily Public Ledger, we get a little more information as to the reasoning that Judge Parker had about the jury instructions. Quote, a sensational turn was taken in the Hargis case at Lexington Thursday when Judge Parker refused to instruct the jury for accessory before the fact on the ground that this offense was not properly charged in the indictment. The only chance for conviction, many believe, lies in the fourth paragraph, which declares that if Cockrill was shot by some person other than Hargis, and Hargis was at the time, quote, so near to such a person or persons that he could give him or them aid or assistance in doing such shooting, unquote. or could, quote, aid him or them in escaping detection or evading or resisting arrest, and if the defendant was in such a position for the purpose of this part of giving such aid or assistance, unquote, then Hargis can be found guilty, unquote. Wow. Let's break that down, shall we? Basically, Judge Parker's instructions to the jury can easily be read as if Judge Hargis was not standing beside of or in the same room with those that shot Cockrill, and if he did not render any aid for escape or helping to hide said shooters, then he must be found innocent. This is after the fact. Again, the trial was about the events that took place before the shooting, not after the shooting. While history will leave very little room for question upon the guilt of Hargis, for now it seems Judge Parker would be in his corner with the jury instructions. Judge Parker would have to defend his stance in the Hargis case. According to the May 12, 1905 Mount Vernon Signal, quote, Judge Parker made an address in the courtroom in which he defends his course in the case, declaring that, from a standpoint of law, the instructions to the jury were so simple that even children could understand them, unquote. So, Parker was hiding behind a standpoint of law when he was making the jury instructions? The May 12, 1905 Breathitt County News article is very long. However, it basically boils down to how the citizens of Breathitt County reacted to the jury instructions. They held high hopes that Judge Hargis and his faction would finally meet justice, that Judge Parker would give them relief from what the law-abiding citizens of Breathitt County felt was a huge miscarriage of the justice system. They now felt that after all the expense of several trials, that this case was not allowed to stand on its own merit. The verdict. The verdict of the jury was no surprise. After all, Judge Parker just handed the defense a huge gift. But would the jury completely agree with him? It would seem that two of the men of the jury did not. According to the Mount Vernon Signal on May 12, 1905, quote, after a second declaration to the court that agreement was impossible, the jury in the Hargis case at Lexington was discharged. 10 of the jurors were for acquittal, and 2 of them refused to be charged from the belief that he should be convicted. He was ordered back to jail, and a motion for bail, argued by the attorneys, was passed upon Monday morning. No surprise was caused by the outcome of the trial, as under the instructions of Judge Parker, no one looked for a conviction, unquote. We get a little bit more information about how long the jury deliberated in the May 12, 1905 Mount Vernon Signal. Quote, hung jury in the Hargis case. In his instructions, Judge Parker made no reference to a conspiracy. The case was given to the jury on Friday night at 9 o'clock. On Saturday morning, there was no prospect for an agreement, and at 2 p.m. the jury was dismissed. They from the first ballot stood 10 for acquittal, 2 for conviction. Application was made for bail. Unquote. To further the evidence for a hung jury, Judge Parker polled the jury. We get more information from the May 11, 1905, The Citizen. Quote, Judge Hargis trial. The jury failed to reach an agreement and were discharged. Lexington, Kentucky, May 8th. James Hargis, the county judge of Breathitt County, who had been on trial for 4 weeks for complicity in the murder of James Cockrill, is still prisoner in the Fayette County Jail, although the jury in the case failed to reach a verdict after deliberating 15 hours. The jury announced to Judge Parker that they had failed to reach an agreement and asked to be excused from further deliberations. Judge Parker questioned each juror separately, and after each had said that it would be impossible to reach a verdict, Judge Parker discharged them, unquote. So, because of the instructions that Judge Parker gave to the jury, they were unable to agree on a verdict. This would set up for a possible retrial for the case. However, the Commonwealth was not done. They would appeal the jury instructions to the Appellate Court of Kentucky. In next week's video, we will dive into the appellate court case as well as the controversial decision about the bail for the defendants. But for now, who do you agree with, the 10 or the 2 men that were on the jury for the Hargis case? Do you think that Judge Hargis should have been convicted or acquitted? Thank you. We at Kentucky Tennessee Living would like to thank you for watching our video series on the Appalachian feuds. Don't forget to hit that like button, as the more likes we receive, the more likely YouTube is to suggest our videos to other viewers. Also, to receive notice when we upload a new video, be sure to subscribe and click the bell notification button. Be sure to double check that you are subscribed, as some of our viewers are finding that they are no longer subscribed to our channel. We thank you for continuing to support Kentucky Tennessee Living as we are discovering the mysteries in Appalachian history.